Hi guys, welcome to Law Troop. I did my LLB from Delhi University and I am practicing law for more than 4 years now. In today's video, we will be discussing the basics of the Limitation Act 1963. Now you don't have to write down whatever I am speaking because PDF will be linked below for you to download in case you would like to. This is just going to be a general discussion. For broader discussions, we are working on a course which will take some time as of now. A blog is in making too, and hopefully it will become active by next month. Let's get started. What is the Limitation Act about? The Limitation Act 1963 specifies the time period within which one can file a suit against another. So, if the suit is filed after the expiration of time period as specified in this act, it will be barred by limitation. Now you must be wondering, why so? Why can't I go to court of law for justice whenever I want? Because for larger good and order in the society, it is considered that there should be a limit to litigation, and the law will assist only those who are vigilant and not those who sleep upon their rights. Let us look at it this way. Supposedly, as a kid, you took a book from the library and forgot to return it. And now, after say 20 years, they want you to either return the book or pay the fine for each day for last 20 years. Not fair, right? So the Limitation Act is about that only. It basically tells you the period after expiry of which a case is not maintainable in court. After the Jammu and Kashmir Reorganization Act 2019, this act applies to all the parts of India including Jammu and Kashmir. Limitation Act is applicable to suits, appeals and certain applications as given in the Act. It does not apply to writ petitions or proceedings before quasi-judicial bodies or executive authorities. Also, provisions of Limitation Act cannot be waived or modified by contract between the parties. The Act consists of 32 sections, last one is repealed, and many more articles. Let us straightaway jump to Section 3 of the Act, which lays down the general rule that if any suit, appeal, or application is brought before the court after the expiry of the prescribed time, then the court shall dismiss such suit, appeal, or application as time barred. It means that if you have given your money to someone who refuses to return it to you when you ask him, say on 10th of January 2020, and the Act requires you to approach the court within 3 years from the date of refusal of repayment of debt, then according to it you should file your case by 9th of January 2023. You cannot file it after 9th of January 2023. The law of limitation only bars the judicial remedy and it does not extinguish the right of the party. What does it mean? Simply said, it means that you cannot go to the court for seeking time-barred remedy. However, if you have a right which you happen to fulfill other than by filing a suit in court, then the Act won't prevent you to get it as it was your right. Therefore, if someone has repaid to you a time-barred debt for which you could not go to court, then he cannot claim it back saying that it was time-barred. There is an important case law on this point, namely Punjab National Bank and others versus Surendra Prasad Sinha. In this case, the respondent took loan from the appellant bank on 5th of May 1984 against fixed deposit receipts which were getting matured on 1st of November 1988, 4 years later. According to the Limitation Act, the bank could not have gone to the court after 3 years from the date on which loan was taken, which is on 5th of May 1984. So what the bank here did, it deducted the amount of loan which the respondent was supposed to repay to the bank from the amount which was payable by the bank to the respondent on maturity of fixed deposit and paid just the balance amount to him. The Supreme Court held that it was permissible to do so because even if the remedy through judicial process has extinguished, the debt still subsists. That right to debt can be exercised in any manner than by means of a suit. Thus, as already discussed, Section 3 only bars the remedy but does not destroy the right which the remedy relates to. Therefore, a debtor may pay the time-barred debt and cannot claim it back on the plea that it was barred by limitation. Other than the right, expiry of limitation does not extinguish defense but only bars the remedy. So the defendant can take defense of something which he otherwise cannot enforce. The provisions of Section 3 are mandatory and the court will dismiss the suit if the suit is time barred, whether or not the defendant has raised the point of limitation. In fact, the court can do so at the appellate stage as well. But it is also important to note that if bar of limitation is not evident prima facie and is rather a mixed question of law and fact, which basically means that the fact that suit is filed after expiry of limitation is not evident from the plaintiff's suit and certain facts need to be proved by the defendant in order to show that suit is barred by limitation, then in such cases limitation must be pleaded by the defendant in his pleadings. We must also keep in mind that if the court, without taking note of the said provisions, decides a suit on merits, that decree is not a nullity. Section 3 is subject to the provisions of Section 4 to 24 which provide for the situations when case can be filed even after expiry of limitation period. Let's see Section 4. According to Section 4 of the Limitation Act, if the period prescribed for filing a suit, appeal or application expires on the day on which the court is closed, the same shall be filed on the day on which the court reopens. If the court remains closed for a few hours on a particular day, it will still be treated as closed on that day. However, it must be kept in mind that the benefit under Section 4 is available only with respect to those suits, appeals or applications which are filed before proper courts, and if an application is filed in a wrong court and the proper court where it ought to have been filed was open on the last day, then no benefit under Section 4 is available. Coming on to Section 5 of the Act, we file an application under Section 5 Limitation Act for condonation of delay. What is condonation of delay? Okay, so it means extension of time given in certain cases provided there is sufficient cause for such delay. For example, if you were to file an application by a certain date and you fail to file it by then, the court might allow you to file it even after limitation period has expired, provided that you satisfy the court that you had a sufficient reason to not file the application before. Whether or not there is a sufficient cause for condonation of delay is a question of fact dependent upon the circumstances of each case. So my illness might not be a sufficient cause for courts to condone delay, but yours may be. Courts will have to look into the facts of each case differently and then decide. An important point to note here is that Section 5 applies only to appeals or applications and not to suits. The simple reason behind this is that if you observe the time limit given in the Act for filing various kinds of suits, it is greater than the time prescribed for filing appeals or applications. So say, if for a suit limitation time is about 3 years, for application it can be about 6 months, or for appeal as less as 30 days. That is why it is felt that a more generous view needs to be taken in case of appeal or application. For the same reason, Section 5 is not applicable to an application for execution under Order 21 CPC, for which limitation period prescribed is 12 years. Although Section 5 is applicable on the private parties and government alike, but where government is a party, a more liberal approach is followed in condoning delay. Now, why so when the government, who has all the resources, should be the one far more vigilant? It is so because it is presumed that government would be pursuing a litigation for larger public interest, and if a matter brought to the court by the government is thrown out of the window, then it is the public that suffers. Also, as the government works like an institution with a number of departments, so decision making is at various levels, which means that any file will go through many hands before it reaches the ultimate decision making authority, which can be time consuming, not to mention the red tapeism in government machinery. On similar considerations, State of Nagaland versus Lipok AO was decided. There is a famous case, Collector Land Acquisition Anantnag vs. Katiji, wherein the Supreme Court also laid down certain principles to be followed by the court while interpreting the application relating to condonation of delay, which are that normally a litigant does not get any benefit by filing a late appeal. Refusal to condone delay might result in a meritorious matter being thrown out. Delay must be explained in a rational and pragmatic manner. Justice is to be preferred over and above technical considerations. Therefore, it should not be presumed that delay caused was deliberate or mala fide. When law, which we read in books, is applied to practical situations, we need to take facts of a particular case into consideration. Thus, what might constitute sufficient cause in one case might not be so in another case. Some examples of what may generally constitute sufficient cause include grave illness, imprisonment, counsel's negligence, bona fide mistake of fact. Mind you, not mistake of law, which can never be a ground for condonation of delay. So guys, this is it for the current video. The videos are not going to be exhaustive because for a general understanding of a topic, it seems enough information in one video. Otherwise, it can become very confusing. As I had mentioned in the beginning also, that we are working on a course for greater understanding of the topics, which should be available soon. Till the course takes its final shape, you can request for online classes on specific topics. Thank you for watching the video. Please like, share and subscribe.